My firm is Ballantyne Law. We are a commercial law firm. We're based in Southport. We practice or act for clients all around Queensland and interstate. The team. Most of you have met all our team now. You might not have met Alex, who is relatively new, or Keegan, but he may have come to one of the meetings. But there's me, I'm the principal of the firm, and Kathy is the next senior lawyer. She is a special counsel. She runs our commercial litigation team, which is her and Nick do most of the work in commercial litigation and other commercial work. You will all know Sydney quite well. She's been a few times. She works with me and Alyssa and Keegan in working in the commercial and property law sections, and Alex is the office administrator. We also have yes, it's made a big difference. And we also have Tim, who is our offshore administrative assistant who works in the Philippines and has also been a revelation for us too. And our bookkeeper is very appreciative of all the work that they've been doing. I did a word cloud of some of the areas that sort of encompass commercial law, because there's always a question about what it means. And effectively, commercial law is we work for small to medium enterprises solving their legal problems, both from the front end in terms of transactional, contractual advisory work, and at the back end dealing with disputes, debt recovery and litigation matters. But there's some of the areas that the commercial work that we do covers. Today I'm going to talk about something specific, which is what I call is a broad term, which I refer to management agreements for business, but depending on the type of structure a client has or your business has will determine the name of the specific agreement. What a management agreement essentially does is assist in the corporate governance and operation of the business. What type of businesses need a management agreement? Partnerships, whether it's a partnership of trusts, partnership of individuals. The type of agreement in that case is called a partnership agreement. Hopefully these days there's not too many partnerships of individuals because I've talked before about structuring and asset protection, and individuals owning businesses is generally not a great idea. I'm not even sure that there are still any professional services businesses that must be operated as a partnership. Law changed a few years ago, so we now have incorporated practices and otherwise. You still see them out there, but ideally people should be operating, if they're operating in partnership, through corporate and trust structures. Second most common type is a company. Proprietary limited company, company limited by shares. The shareholders could be trusts, other companies or individual ownership. And in that case, you're talking what we call a shareholders agreement, which is what I'm going to focus primarily on today because that's probably the most common one that we deal with. The third and increasingly less common type of business ownership structure that we see is a unit trust, which is similar in some ways to a company in that the ownership is divided among equal or what we call units. And a unit holders agreement is the type of management agreement in the case of a unit trust. Sarah, do you deal with unit trusts still much these days?
Usually only in association with super funds.
Yeah. Why do we need one of these agreements? And I'll talk specifically about shareholders agreements. To deal with disputes. Now, it's probably fair to say most people who go into business with another person have an existing relationship with them. They know them somehow, whether it's a relative or a friend or a colleague or someone they've decided to go into business with them. And no one goes into business planning to fail or planning to get into fights or disputes with their business partner. But what inevitably happens is disputes will arise at some point. Decision making might be deadlocked. People have a different view on what their original agreement was. And if you don't have something written down, I can guarantee you that the two shareholders will have a different perspective on what their agreement was when they started the business. And these sorts of disputes arise mainly in two areas. One, when there's no money or they're having financial difficulties, or two, when they're making a lot of money and one of them might be feeling that they have done more work than the other. So a shareholders agreement is one of the ways that we can deal with a framework for dealing with those sorts of disputes. Corporate governance. This is an important one when businesses grow or as they grow. Again, when people start out and they have a clear picture of what they're doing, we're not there to tell them how to build their widgets or sell their product or provide their professional advice. But what we do want to give them is a framework for decision making and a framework for planning. And as businesses grow, that becomes more important. So having regular meetings, having an annual business plan, having a budget meeting with the decision makers at least on a regular basis in a formal way really assists a business plan strategically, and as it grows then there's fewer problems on the horizon. We have a client which is a software company which has been around for a few years, and there's 4 main owners and they all do a different thing. There's a software developer, the guy who put in most of the money for it, there's an accountant who deals with the trust accounting issues because it's a trust real estate business, and there's a sales guy. Now all of them are good at what they do, but they have built this company which has done very well and is now in a position where it could potentially be taken over by a rival or an international company at a valuation of anywhere between 10 to 20 times revenue. The problem that they have is that there's no strategic plan, there's no CEO, there's no one in charge who can say, the owners want to sell this thing for X million amount of dollars, we need to put this business into a position to do that. Having a shareholders agreement that allows them to meet and put these plans in place, employ a CEO, deal with the decision-making process would assist them greatly. Finally, investment. This is a big one for startups. So we hear a lot about startups these days, and they can be fintech or other types of businesses. What they're looking for generally is investment, and what investors are looking for is stability in decision making. And one of the things they want to see when there's multiple owners is again a shareholders agreement and a framework for decision making. So having an appropriate agreement in place that deals with founders' rights, deals with decision making is very important. So, what is a shareholders agreement? It's a contract. That's all it is. It's different to a constitution. It's a contract between generally the company itself, between the shareholders of that company and sometimes the key people, because the shareholders might be a trust or company associated with an individual, but sometimes you want to bind the key people as well. What kind of issues does shareholders agreement address? The structure of the business, who put in what, how many shares are there in the company, who owns those shares. Management, how decisions are made, who does what in the company. Direction, what is our plan for the future? What's our exit strategy? The responsibilities of specific directors, is there a CEO, is there a managing director? What decisions can they make themselves without having to go to the board? What do the shareholders have to make decisions about? Acquisition and disposal of interest, this is a big one. You don't want one of your shareholders being able to go and sell their shares to anyone. You want to decide who you're in business with. So you need to have you need to have restrictions on how the interests in that company are dealt with. And exit strategies, what happens if someone dies? What happens if someone gets divorced? What happens if someone gets injured? How does the business continue to operate and what happens with those shares? Dispute resolution, you don't want people running off to court and spending significant amounts on lawyers' fees. Reasonable amounts on lawyers' fees is okay, but not significant amounts. But having a framework to deal with dispute resolution, alternative dispute resolution, notices of disputes, trying to resolve issues reasonably before we run off to court. What can they also? So those agreements are probably what has to be addressed by a shareholders agreement. There's other issues that we generally recommend. Tag along and drag along provisions. So in the example I gave before about the business that might be bought out, you might have a majority shareholder who decides he's going to find a buyer for his interest. He might own 60 or 70% of the company. What a drag along provision is that rather than the 40% minority shareholders holding out and saying, no, you can't sell those shares, we want to keep being in the business, a drag along forces them, when there's a reasonable offer, to sell their shares at the same price as the majority shareholder or shareholders. And tag along's the opposite. If a majority shareholder or a majority group of shareholders decides they're going to sell for a reasonable price, minority shareholders can say, hang on, you can't forget us, you have to take us with you and you have to get the same price for our shares. So involuntary exits are what I talked about before. So buy-sell agreements are a methodology of funding what we call involuntary departures. So really the key ones are death and permanent injury. So if your business partner dies or if your business partner suffers from an injury, do you want to be in business with their spouse? Do you want to be in business with their children? You have to deal with what their estate plan says if you don't have a proper plan in place. So what a buy-sell agreement can do is trigger a sale of the deceased or injured party's shares to you at an agreed on methodology of working out the value. So the business can continue and the family of the person who's been injured or sick or died can receive value for the interest in the business. Funding, so if the business needs to be funded, does the money come from the current shareholders? Does the money come from external sources? Does the money come from raising capital? All of these can impact the way the business operates. And what are the responsibilities of a key person? So does your business partner have to work in the business, or are they a silent investor? To be an owner of the business, do you have to work in the business, or can you get someone else from outside the business to be an owner? And founders' rights is a big one for startups. Again, often the people who put in the original sweat equity and the original capital and the original ideas into a business want to make sure they might have additional rights to deal with the growth of the company. Something that also becomes common is, do you want to put in place a scheme to allow employees to become owners of the company? And that has taxation and other implications, and having an appropriate plan in place can be very helpful. Quickly, I mentioned constitutions before. When I talk about constitution, we're talking about specific constitutions which a company may have, or what we call replaceable rules, which are rules that are imposed on a company. A constitution are really formal rules that are defined types of shares. They deal with their standard decision making, and they're often not appropriate for all businesses in terms of the day-to-day operation. A shareholders agreement is a bespoke way of actually saying this is an agreement between the parties that we can use for our specific business. It's not an off-the-shelf product. It's not a set of rules in the Corporations Act that we say should apply to everyone. Common features of shareholders agreement. When you're talking about the issuing and disposing of shares, you might have rules around who can be a shareholder. Do you have to work in the business to be a shareholder? Do we have rights of first refusal? Who can we transfer shares to? And I talked about before about voluntary and involuntary departures. You might have an arrangement that says if one of the parties gets divorced, that's a trigger to sell their shares because we don't want to participate and become involved in a nasty family law dispute. And the tag-along, drag-along provisions. Valuation's a major interest. How do we decide what a person's value is in the business if one of those events happens? We can have ways of appointing external valuers. One of the common ways we deal with it is just have the parties meet at the start of each financial year and say, for the next 12 months, this is what the value of the business is, and if an event happens, that's what you're going to pay for your shares, or that's what you're going to receive for your shares if you have to sell. Decision making. So there's some decisions that you might want to have made by the board, and those decisions might be made by way of majority decision. They might be made by, if they're very important decisions, by special majority, which might be 70% of the owners, or they might need to be made by unanimous decision. Where shareholders don't have a place on the board, there might be some types of decisions, things like selling the whole business, which you might reserve just for the shareholders themselves. How often should board members meet to talk about those strategic decisions? How often should they meet to talk about annual business plans? How often, what decisions do require unanimous agreement, special resolutions, or majority decisions? What happens if there's a dispute? I don't know because the thing's not working. So dispute resolution is what I talked about before, where if there's a dispute, do we issue notices to each other and say, look, I've got a problem with this issue and I want you to try and resolve it, and if you don't resolve it, we're going to appoint a mediator, or we're going to appoint an arbitrator. You know? We're going to do something else. I've only got a couple of... Just press space. That's all right. I think there was only one left after. Yeah, so issuing notices, dealing with alternative resolution process. Next one. Go back one. The final one I wanted to talk about before, this was going to be the big finale, so you've ruined that for me, Pete. Thanks. dealing with deadlocks. There's a number of different ways you can deal with deadlocks, but I chose these two because they sound cool. In practice, they're probably not as cool as they sound. Let's say a business has a deadlock and no one can agree on anything, and we want to say, well, one of us needs to take over the business and buy out the others. The Russian roulette method essentially sees the party who wants to buy out the others nominate a price for the shares and say, I think the shares are worth $1 million. My shares are worth $1 million. Once he puts that price down, the other parties that he wants to force to buy him out can say, well, actually, no, we're going to buy you out for that same price. So it keeps people honest. Texas shootouts are a similar method where each party writes down in an envelope what they say the shares are valued at. They all open the envelopes together, and whichever price is the highest whichever price is the lowest is what that person receives for their shares. So again, it keeps people honest in deciding, I'm not going to value, if I'm a seller, I want it to be very highly valued. If I'm a buyer, I want it to be very low. So I've got to put something that I'm happy to live with, whether I'm a seller or a buyer. So that's all I have today. That's an AI image that I said of lawyers signing a shareholders agreement with a Texas shootout clause in it. So I think it did a pretty bad job of that. And does anyone have any questions? Yes.
So one of the biggest issues that I can come across in businesses where you have multiple owners is when one of the owners gets divorced.
Yes.
And that share potentially becomes an asset that can be...
It'll be a matrimonial asset, yeah.
So can you deal with that in the agreement?
Yeah, so that's what I'm talking, when I talk about these involuntary trigger clauses, the divorce of one of the members can be a trigger to say, if one of the parties separates permanently from their spouse, then they have to sell their shares to the other partners, or they have an option. The other partners have an option of buying those shares at an agreed methodology for valuation.
Is there an opportunity to obviously reduce that value, or
if you want to expose yourself to the family court process, you might include an unreasonable methodology. But generally speaking, you're going to have as I said, there's lots of ways of dealing with it. Having the agreed value at the start of each financial year is not a bad way, or when the tax planning gets done, so you know what your revenue has been, and saying this year, if anyone has to sell their shares, each share is worth X amount of dollars. And whether that's a death or permanent injury or divorce or I want to retire kind of agreement. Yeah. You can also impose penalties or otherwise where you reduce the price if someone's a bad leaver because they've breached the agreement or potentially got divorced. But it can be an issue if the other party's lawyers think that you're trying to pull a fast one on the value, it might be an issue.
Yeah, but you're saying that that's not a standard included in that, it's something that can be added in as an extra. I would have thought that would have just been a standard in every agreement.
No.
I would have thought that would be a biggie.
No, it is a biggie, but it's not always in there.
Yeah.
It's rare. Things like buy-sell agreements and otherwise, if you go and order a shareholders agreement off the shelf from a legal provider, it's rarely going to include those things. They're complicated because they're not. They require some thought and discussion and negotiation, and that's why often getting these things done at the start of a business life is sometimes a bit easier than midway through. But we've got. No, it's not. We've got a business at the moment, a mature business, multi-gen. Others are all in their 30s or 40s, so they've got different needs. They've got different wishes. One of them's looking at retirement and exit. The others are looking at growth and otherwise. And how do we succeed? How do we get this guy out on a stage basis without costing the business? Because he's got lots of residuary or legacy loan arrangements and otherwise. Professional services business is sometimes a difficult one. Some take the approach that you don't pay anything going in and you don't get anything going out. Others say, well, you have to buy into the business, and how do we get senior partners out the door? So there's lots of different ways of doing it. It depends on the circumstances.
Mate, I've got plenty of blokes who have started their own business and they either didn't back themselves to have as much success as what they've achieved, or they didn't have the capital funds at the beginning to invest in something like this. Is it any more difficult to put in place something to
No.
agreement for a mature business.
It just might require more negotiation because of those issues of people's differences about their perspective on what they're doing. But no, it's not. The right time to do it was yesterday, but the second best time to do it is today. So, the longer you leave it, the more difficult it gets.
Yeah.
It can bring forward those difficult discussions.
Yeah. Yeah, and that we've seen it happen where people have this and then they decide I'm out. I don't want to do this anymore, and you buy me out.
Yeah.
Yes.
Yeah. Minority shareholding
Yep.
rights.
Yes.
Is this could be included in this?
Yeah. So, and that's an important one, because if you don't have a shareholders agreement, as you'll appreciate, the Corporations Act has provisions to deal with shareholder oppression and minority shareholders who get dudded. But if they're a party to an agreement that's very clear about how decisions are made and what things, it's a lot more difficult for the minority shareholder to run up to court and say, we need to have a receiver appointed because I'm being dudded here, because the decision-making framework that they've agreed to as being a member of this company has already been decided.
So anyone that really wants to buy in.
Yeah. Needs to be a part, and generally the shareholders agreement, anyone who becomes a shareholder, anyone who sells their shares to someone has to follow this process, and one of the processes is that an incoming shareholder has to sign a deed that says they're a party to the shareholders agreement. Right. And the way you protect minority shareholders is through that decision-making hierarchy, where you say these are decisions that require that are deferred to the managing director. These are decisions that require board approval. And of those, these are the ones that require just a majority, 51%. These are ones that require 75%. These are ones that require 100%. And these are ones that require shareholder approval. Yeah. So that's how you really preserve minorities, is saying, well, the managing director can spend 20 grand without getting board approval, but anything above that requires this. Anyone high, yeah. So you go through that. Yeah. All right.
Lovely,
Thank you.